This is Peggy Clary of Clary Law Offices, and this is our daily video chat about a topic of estate planning. And tonight I thought I'd talk about a pretty commonly asked question I receive as an estate planning attorney, and it's a good one. So, is there anything such as an ironclad will? And when I think about that question, the first thing that comes to mind is a statement by Benjamin Franklin that talked about the only thing that's certain are death and taxes. And while I can't comment on the taxes, I can tell you Benjamin Franklin was correct about death. So if you're one of those individuals that lives in fear, and a valid fear of your family having the ability to challenge a will, which you have taken time to create, it's important to think about the will challenge with really three different components. So the first component talks about what is a will, because if a will is not validly executed, then it's not going to withstand a challenge. So Florida law is a really straightforward statute which governs what's a valid will. And you have to be over 18, or if you've been emancipated, the court recognizes you as an adult. And then as the person creating the will or the testator, you have to sign it at the end of the document. And then you have to have two witnesses that sign as well. And you all either have to sign together, or if maybe you draft this document at home, you then go back and reaffirm in the witness presence that that's your signature. And it's very important that when you decide to make a will, that at least you think about, have I met these basic requirements? And Florida doesn't require to use an attorney. There's many people that write their own kitchen table will, but you just need to make sure from an execution standpoint you have a valid will. Now, the next two components that bring the most challenge really pertain to two distinct areas. The first is capacity. So was the person who executed the will at the time having the mental ability and then be in the right mindset so they were able to make the will? And Florida uses a standard for that, and I like to think about it as, did the testator know the objects of their bounty, where they're going to go, and then the import of that. Now, it's a very legalese phrase. Some people say clear as mud, but really at the time you made the will, did you understand what you owned as assets, where they were going to go, and why that was important? So having just some basic knowledge. You don't have to remember your account numbers, but you at least have to understand what you have, where it goes, and why that matters. Now, the third thing, or the third component that comes into making quote unquote an ironclad will, is to think about the circumstances of how this will was created. So you can challenge a will for undue influence, issues like we just talked about, the person lacked capacity. But one of the biggest areas that comes up is, did the person who make that will do that freely and voluntarily? So I always give the example of, it's fine if you as the daughter drive your mom or your dad to the office to them to meet with the estate planning attorney. There's nothing wrong with that. But where it can get a bit more challenging is the attorney-client relationship is with the attorney and your parent. So that parent needs to feel free to make a document that reflects their true wishes. And there are some cases where, adult children are asked to wait outside in a waiting room before I meet with them, just to make sure I have a parent who's really sure in making their plan as an individual and maybe not feeling pressure or unduly influenced. Now, undue influence has many more components to it than that brief example I gave, but if you're thinking about creating an ironclad will, which is a common issue for a lot of people who want to make sure their person they've selected to inherit will not have to go through any kind of litigation. The three things to remember are really make sure it's executed in accordance with the terms of Florida law. So no one could say it just doesn't fit the standard of what it needs to be. And then thinking about capacity and also balancing that out with circumstances of how it was executed. So there's a way to verify the person did this will freely and voluntarily. So I hope this information was helpful to you. We at Clary Law wish you a life of civility, dignity, and respect. And if we can help you plan to create your own ironclad will, or at least hope it will withstand challenge, we stand ready to do it. And thanks again for your time.